on behalf of CMR University School of Legal Studies, welcome you all to an engaging session based on the theme Cooperative Federalism. We are honored to have with us today a highly regarded senior advocate, Supreme Court of India, and experienced professor of law, Mr. Mohan Katarki. It is with great honor and privilege that I introduce you to you, Senior Advocate Mr. Mohan Katarki, a distinguished legal luminary and a senior advocate designated by the Supreme Court of India. He also serves as an honorary visiting professor of law at Bangalore University's Law College and a professor of practice at CMR University School of Legal Studies. Mr. Katarki is renowned for his profound expertise in transboundary water law, specializing in equitable sharing of federal and international river water resources. He has represented several states in pivotal cases before the Supreme Court and interstate water dispute tribunals, including those concerning the Kaveri, Krishna, Ravi Bees, and Mahadayi rivers. Currently, he represents Karnataka, Odisha, and National Capital Territory of Delhi. As an accomplished scholar, Mr. Katarki has published numerous papers on transboundary water law and constitutional matters, sharing his insights at national and international conferences and seminars. He has furthermore made significant contributions to legal education, serving as a member of Academic Council in the National Law School of India, University, Bangalore. Mr. Katarki is also the Vice President of the Bar Association of India and plays an essential role in Karnataka State Law University's Board of Management and Planning, as well as in KSLU Student Law Review and Bangalore University's Law College Journal. We are honored to have him share his invaluable expertise in today's seminar that is more relevant than ever. Please join me in extending a warm welcome to Senior Advocate Mr. Mohan Katarki, sir. We welcome you, sir.
Good morning to all. At the outset, may I thank CMR Law School and particularly my favorite teacher in international law, Professor T.R. Subramaniam, for inviting me to deliver a lecture on a topic that is of seminal importance, even though it is less explored and least researched. We all know, as students of constitutional law, that federalism is a moral precept or a principle of constitutionalism to be applied while designing the constitution or interpreting the constitution. Federalism touches the nerve cord of power politics, particularly in multicultural societies like India, Canada, or the United States of America. There are two models of federalism, namely federal centric and state centric. However, there could be a hybrid version. A hybrid or quasi federal model is the model which India has adopted. Co-operative federalism or coercive federalism is the method to interact in quasi-federal system. If it is purely state-centric or federal-centric, the question of intense interaction does not arise. But if it is a quasi-federal model, like we have in India, the question of intense interaction arises. And if interaction becomes necessary, the tension is bound to come up, and therefore an approach is suggested to solve the problems by cooperative approach or by coercive approach. These are the two models which are known to be competing models in addressing the grievances in a federal system, which is quasi-federal system. If the tension arising from the interactive model of governance is not addressed, for some reason, for political reasons, if these tensions are not addressed, it might develop into a fault line, breaking the nation in some extreme cases, as it happened in the USSR in 1990. That is, Union of Soviet Socialist Republic. Students of this generation are not familiar with that, but students of my generations have seen how a mighty USSR came crumbling down in 1990. Of course, the reasons are many, but one of the reasons which is largely attributed is failed structuralism in the decision making in USSR because they adopted top-down method instead of a cooperative method in their interaction with the federal units. The relationship between the center and state and between the states in India, as I said, is quasi-federal model as interpreted by the Supreme Court in series of decisions. It is nowhere written in the Constitution that we adopt quasi-federal, but on interpreting various provisions of the Constitution, the Supreme Court has largely come to the conclusion that what we have is a quasi-federal model, which is not fully federal, but it is not fully unitary model. If you go back a little to the history, when India was first conceived as a political model by the British Raj by enacting 1858 Act, it was a unitary model. There were no, in a strict sense, provinces or presidencies. No doubt, there are presidencies like Bombay, Calcutta, and Madras, but they derived their powers by delegation from the center, that is the government of India. And of course, over the government of India, there was a Secretary of State who lived in London, who never came to India and was a member of the British cabinet. So that unitary model continued for long. It was partly decentralized in 1915 and 19 when the British Parliament enacted the Act to introduce a diarchy system of government. A provincialization took place, demarcating certain areas for the provinces and certain areas for the central legislature. That is how the central legislature was conceived and invented, and that is how the old Parliament building, which we see in Delhi, was built as a central legislature in around 1920. The 1935 Government of India Act departed from the concept of unitary government or even a partial provincialization under 1919 and adopted a proper federal method by properly dividing the subjects of governance between the federal government and the provincial governments. The princely states, which were supposed to join India by accession and form a federation, however, did not take place because none of the princely states in 1936 signed instrument of accession. That's a separate story. Now, the Constitution of India, framed in 1950, after elaborate debate in the Constituent Assembly, one of the finest documents which it is praised around the world, has adopted a federal model, which on interpretation being said to be a quasi-federal model, with a bias, some say, towards the center, some say towards the state, but certainly it is a bias towards the center because the residuary power is with the center, not with the states. In United States of America, which is said to be a perfect federal model, the residuary power, that is power which is not vested in the state, which is not vested in the center, lies with the state. So that's a kind of a system they have adopted. But for the good reasons, we have not adopted such a center, except in the state of Jammu and Kashmir for a different reason, which is a subject matter of debate in the Supreme Court on the question of removal of Article 370. Because Maharaja of Kashmir had signed accession only in respect of three subjects. Therefore, the residuary power remained with the Maharaja, who later transferred it to the Kashmir Constituent Assembly. That's a different matter. So this quasi-federal model, which India adopted in 1950, has come along in the last 7 decades. And to implement this model, what is the methodology we have adopted is the question. Have we adopted a cooperative federalism, that is a cooperative method to interact? or a coercive method to interact. That is where the center ultimately wields a veto power or a power to coerce the state to fall in line. So this is a question on which we have to look into the little details of the constitution to come to a conclusion. Let us see the landscape, how it happens. This question of quasi-federalism and a cooperative approach to address the problems arising from the interactive model of federalism is more in case of natural resources than in any other case. Of course, the subject has not received much attention for various reasons. But as you all know, natural resources are the resources that are part of nature, known as gift of nature. They do not belong to any individual or to any group of people. They are water, forest, oil, and mineral resources. These resources are abundant in India, undoubtedly. These are the resources that are owned by none. The doctrine of res communis, which prevailed in Roman law, has been applied in English common law with regard to the natural resources. The doctrine, put simply, it means that what belongs to all belongs to none, and what belongs to none belongs to all. So, on the basic question, who owns the natural resources? The legal point is that none owns because it belongs to all. It is the heritage of mankind. In international law, which has further defined the doctrine of res communis, has developed a concept called common heritage of mankind. So these resources are technically owned by none, but people do have the rights, not ownership rights, but usufructory rights, that is to use. To that extent, the rights of the people in the forest produce, the rights of the people along the banks of the river, that is riparian rights of individuals, are protected. Subject to this protection, the property as such is not owned by anyone. The state acts as a trustee, not as the owner again. The doctrine of public trust is developed to describe what sort of ownership or what sort of control the state has over the natural resources. This doctrine has been accepted by courts in England, courts in India, and everywhere. So, public trust doctrine is a doctrine which now explains who owns and in what capacity the state owns the natural resources or properties in the natural resources. There is also Article 296 of the Constitution. Many have been referring to that. That refers to principle of bona vacantia. That is, if the property is not owned by anyone, then it will be owned by the state or the center, as the case may be. But natural resources are not strictly the property in that sense. That is a resource that, as I said, res communis, and that is the principle of common law, which India has also adopted by reference to Article 372 of the Constitution, that is continuation of all existing law, which includes principle of common law. Therefore, as the position continues, the natural resources, namely water, minerals, forest, fisheries, are not owned by anyone, including the government, but government holds them as a trustee for the benefit of public. This is how the broadly the landscape with regard to the natural resources in India or in the common law. Now, how the Constitution has conceived, designed the role of center and the states with regard to the management of natural resources. If you look to the constitution, it falls in three parts. First is natural resources that are vested only with the center. There are some natural resources, I'll point it to you, which are vested under the legislative and executive competence of the center. The center can make law or exercise executive powers. These are oil under under entry 53 of the Union list of the seventh schedule, minerals under entry 54 of the Union list, fishing and fisheries beyond the territorial water under entry 57 of the Union list. These are the resources with respect to which center has all the powers to legislate and exercise its executive powers. There is no question of consulting any states on these issues. But there are items which are only vested in the state, like fisheries, which is a natural resource. It is vested in the state by virtue of entry 21, sorry, yeah, by reference to entry 21 of the state list. As a result, the state has exclusive control over these natural resources. Then we have natural resources that are vested with both center and the states. For example, and most important one is water, which is vested with both state and the center. The entry 17 of the state list talks of water. That includes even the water of interstate river also, subject to not causing injury to the neighboring state, which I'll come to you later. But entry 17 is made subject to entry 56 of the Union list if the Parliament by law declares that it is necessary to take control of the regulation of an interstate river. So, subject to entry 56, the state has an absolute power to legislate or exercise executive powers in respect of water, even with respect to the interstate water, provided it falls within the equitable share of a state. Now, here comes the question, the relationship between two states with respect to water, because we have seen that quasi-federalism or cooperative approach in federalism is not only an interaction between the center and the states, it also includes what sort of interaction is constituted by the constitution between the two states with regard to the sharing of the resources, which we call shareable resources. So one of the most important shareable resources is the water. As we have been reading in Bangalore, today the state is facing a lot of agitation with regard to the sharing of Kaveri water. I did not go into detail about that since I appear for the state of Karnataka. But speaking constitutionally, let us explore what is this water. As I said, water is the state subject under entry 17 of the state list. The Supreme Court, in a special reference in 1991, when the state of Karnataka passed an ordinance attempting to vacate the interim order passed by the tribunal, then the court said, the constitution bench, Justice Sawant, that the state cannot legislate in respect of water beyond its equitable share. That means it can legislate to the extent it will not cause any extraterritorial injury to a neighboring state. So this is how the principle of cooperative federalism is introduced in the sharing of interstate water, that both the states will have to live together and share the water on a cooperative method. But when it comes to the cooperative method, what do we understand? Do we understand that states should always sit at the table and negotiate, or negotiation is only a first step, and finally a coercive method of adjudication comes in. Well, the constitution makers adopted both the methods. Firstly, the constitution conceives under Article 263 of the constitution that any interstate issue should be resolved by talks between the states under the mediation of the center. The model is under Article 263 of the Constitution. That's why we see regularly zonal meetings of the interstate councils. In fact, today there is a zonal meeting of the northern states presided by the Home Minister in Amritsar. And one of the issue I'm told yesterday by the council who briefed me that the SYL canal construction is prominently being listed for discussion. So interstate council is one model which the constitution has conceived for resolution of the disputes by cooperative method. Next is if you do not resolve by or under the advice of the interstate council, or interstate council for reasons does not take interest, it happens. It's not that interstate council takes interest in these kind of things. Most of the time it doesn't. Then what to do? Then the obligation is on the states to share information and negotiate bilaterally with the other state with the help of mediation of the center if necessary. The center also owes an obligation as a head of the family, otherwise it has no powers as such to interfere in the resolution of the disputes between the two states. But as the head of the family, as Narasimha Rao had very famously put it in 1992, that though I have no powers as the prime minister, or our government has no powers at the center, but at the head of the family, if the two states are willing to come and sit across the table, we'll mediate and try to resolve the issue. That's how the doctrine is laid. So mediation is another thing. Then finally comes an adjudication. But interestingly, you must all know that one of the hallmark of the federal system is a provision for compulsory adjudication of the disputes either between the states or between the states and the center. No federalism works unless there is a mechanism to address the disputes between the center and the states, or between the states by a compulsory adjudication by an independent authority, which is the highest court of the land, that is Supreme Court of India. So that provision is there under the Indian Constitution. Under Article 131 of the Constitution, all disputes which cannot be resolved between the states or between the state and the center can be agitated before the Supreme Court, subject to the conditions mentioned therein. However, having regard to the technical nature of the matter, the constitution makers have created a separate provision called Article 262 of the Constitution for establishment of a separate forum for adjudication of the water disputes. That's how the Parliament in 1956 ousted the jurisdiction of the Supreme Court under Article 131 and established a tribunal for adjudication of the water disputes. Now, this Act of 1956, if I tell you, is not a concept of compulsory adjudication straightway. If you read Article Section 4 of the Interstate Water Disputes Act, the center can constitute a tribunal only when it is satisfied that the dispute cannot be solved by negotiation. Therefore, the principle of cooperative federalism is very clearly made part of the act by the parliament. It is the obligation of the states first to explore the resolution of a dispute by negotiations, by method of give and take, by method of understanding in a harmonious way. And if the center is convinced that this attempt was made bona fide and it has failed, then only it will constitute a tribunal for a compulsory adjudication of the water disputes. When I say compulsory adjudication, what I mean is that, as you are all aware, in our private dispute, if I am aggrieved by something, I have a right to file a suit. under the Civil Procedure Code. That is called compulsory adjudication. Nobody need to uh, monitor my right to file a suit. It is a different matter whether court will entertain a suit or not on the merits. But I have a right. Similar right in respect of water is not granted. Therefore, there is a step, that is, first to resolve the dispute by negotiation, because the law envisages and thinks that it is the obligation of the parties first to adopt a cooperative method uh, and solve the dispute by cooperation among themselves than invoking a compulsory adjudication where, as you all know, issues are adjudicated by applying hard and fast rule than by adjustment of equities. Of course, equity adjustment do take place in adjudication, but hard and fast rule are also applied. In fact, they are applied providently. So this is how the cooperative federalism is envisaged in the constitution, and the principle parliament rightly enacted under the Interstate Water Disputes Act by making it a condition that before you invoke a compulsory adjudication by seeking a constitution of a tribunal, you should first convince the central government that you had explored all methods to solve the dispute by negotiation, and it is only due to the failure of such a negotiation we have come. This principle of negotiation in water dispute has also a background in the United States of America. In the United States of America, the Supreme Court exercises original jurisdiction, and it is a sort of a compulsory adjudication, because if the cause is brought before the Supreme Court, it is duty bound to adjudicate. Even then, a threshold rider is put by the US Supreme Court saying that we will not adjudicate the interstate issues unless we are convinced that the states have failed to arrive at a solution by negotiating among themselves and arriving at a solution. So this principle of cooperative federalism in water dispute has its origin in the US Supreme Court, where this condition is insisted. The Parliament, apart from enacting Interstate Water Disputes Act with a threshold requirement of negotiation to reflect the principle of cooperative federalism, at the same time also enacted River Boards Act, an alternate machinery for the resolution of the interstate disputes. It's one of the very important act where it is fully conceived that the differences in the sharing of water between the two states should be resolved by cooperative method, that is, by a board constituted by the central government if the states want. And the board will consist of experts from all the states, that is the basin states, and they jointly decide what is good for the basin. That is how the concept. But unfortunately, since the enactment of River Boards Act in 1956, not one board has been constituted in India. This is a very unfortunate thing, because the constitution of the board requires consent of the states. Since water is a state subject under entry 17, the parliament thought without the consent of the state, it cannot constitute a board. Because once the board comes, the powers of the state under entry 17 gets completely displaced by the board. Board takes a decision with regard to the development of water resources, where dams should be constructed, where canals should be cut, where the water should be served, which side of the farmers should get water during what season. Those decisions will be taken by the board. Therefore, a consent of the state is necessary. But no state has ever given a consent for this constitution of a board. So no board has come. In fact, In Karnataka, once we had tried in respect of Mahadayi water dispute, since it's a very small river, the requirements of Karnataka are not much. There is large water, according to us, which Goa doesn't agree, of course. If a river board is constituted instead of a tribunal in the lengthy litigation, it will serve the purpose. But unfortunately, the advice did not go through for political reasons. So no request was made for constitution of a board. That's how it remains. But there is one board, I must tell you, which is outside the Act of River Boards Act. It was constituted before the Constitution of India was enacted in 1949, when Dr. Ambedkar was the earlier a minister for labor in the government of India, and at that time he was in charge of water resources. And in his capacity, he took keen interest for enactment of a special law, that is Damodar Valley Act. By that act, they created a corporation called Damodar Valley Corporation, modeled on the basis of Tennessee Valley Corporation, United States of America, and that is an independent body. Today, it looks after the development of water resources in Damodar Valley between the contending riparian states, Jharkhand, Bihar, and I guess West Bengal also in that. That is how. The same model which Ambedkar had envisaged under the Damodar Valley Corporation, which was based upon the Tennessee Valley Corporation in the United States of America, was conceived, has been conceived under the River Boards Act. But as I told you, that so far, not one river board has been constituted in India. So this is how the cooperative approach is reflected in the constitution with regard to the water, and it has been implemented by the parliament by rightly putting a rider before the constitution of a tribunal that there should be negotiation. It is only in case of a failure of bona fide negotiation a tribunal should be constituted for a compulsory adjudication. Secondly, by providing for constitution of a river board with the consent of the states, which takes over the development of the basin as an independent expert body. This is how the scheme of things are under the constitution and implemented by the parliament subsequently. So then we move to the next. Despite, which is a very controversial subject nowadays, despite a subject being a state subject, like a water of the intrastate river. We discussed about the water of the interstate river. Forget about that. Now come to the water of the intrastate river, or a water of the intrastate river to the extent it is already allocated by a decision of a tribunal to a state, or with regard to the fisheries and other things, which are the state subject. The parliament has enacted a law which has given or power to the central government to approve or disapprove a particular project of a state if it affects the interest of environment or the wildlife or the preservation of forest. So this overriding power which the parliament has acquired and vested the executive powers in the center has been a subject of very heated discussion in India, because by virtue of this power, the states have authority with regard to the approval or disapproval of the projects sent by the states under the Forest Conservation Act. This is how a method is invented to avoid a confrontation and to promote cooperative federalism under the Constitution. Then also another source of confrontation which has been talked a lot, which everyone is tired of now, is the center exercises a lot of power over the purse. How does it exercise? So this is a very interesting subject. We all know that as a principle of federalism or quasi-federalism, that each government must act within its enumerated power. So center must act within the enumerated powers on the union list, or under the concurrent list. Similarly, state under the state list or under the concurrent list, and subject to the procedure that if there is already central law occupying the field, the state law cannot prevail unless assent is granted. But despite this, there is a way to bypass the whole system. That is Article 282 of the Constitution. Article 282 of the Constitution, if you read, it does not curtail the spending power of the union government only on the items under the union list or under the concurrent list. It empowers the union government to spend money in respect of items which are outside its control, which could be in the state list, provided it is in public interest. So, by virtue of this power, the center, which has a large resources, because the taxation powers are largely towards the center or biased towards the center. Apart from that, the center has a Reserve Bank of India, which has the power to create currencies, and as a result, we are able to borrow and monetize and run a deficit budget, which is one of the most important aspects which the states do not have. In fact, today one third of the budget of the central government, nearly 11 lakh crores, comes from the borrowing and subsequent monetization. So this power the states do not have. As a result of enormous power which the center has over the money, it is able to conceive the schemes for items which are in the state list, for instance, rural development. All these kind of things have been part of central planning through the Planning Commission earlier, now the Niti Aayog. Therefore, the center has acquired enormous powers by virtue of a purse to interfere in the states, and this again raises a question of cooperative federalism or coercive. Is the center adopting a cooperative federalism approach to do the things by cooperative approach by consultation of the states, or the center adopts the its power of purse to withhold money and create a undue pressure on the states. This is a subject which each state has its own grievances, that our quota of the uh, funds are not given, we have been discriminated. These are the things, but this is how a spirit of cooperative federalism is being put to test in India. The purse is so strong that sometimes the states even do not like to complain. For instance, I'll tell you the again going back to the water. The it is a state subject. The state has to find its own resources for building up the dams or canals or harnessing water. But the center has several schemes right from the 1950 where it can fund the state projects provided it meets certain criteria. So, by virtue of that, the center has been able to interfere in the development of water resources in the state by withholding grant or by giving uh, some extra grants where it thinks that the state is acting as per the wishes of the center. So, this how the cooperative federalism is put to test in India. Largely speaking, as I said, the Constitution of India envisages a quasi-federal model and a cooperative approach in resolution of the differences which arise in the interactive model of the quasi-federalism. But the actual practice in these days, particularly with regard to the regulatory measures, it has, or with regard to the spending powers of the union beyond the items on which it has the power to make laws. The spirit of cooperative federalism has been to some extent compromised, and the coercive federalism has come into play. Hope as the time comes, we revert back to the cooperative federalism and continue to thrive as a nation, as one nation by spirit, because India is a nation of multicultural society. Unity in diversity is important, and I'm sure that in course of time we will, irrespective of the political parties, adopt ourselves to the better cooperative federalism, better method of cooperative federalism, and promote the development of the nation. Thank you very much. I don't like to take much of your time.